Hi everybody, you're very welcome back to Law Hero. My name is Jennifer and today we are continuing on our Back to Basics series whereby we all get a little bit more acquainted with the broad kind of terms of the legal profession in Ireland and the law in Ireland. And today we are looking specifically at solicitors. From a more theoretical standpoint, and in Ireland as well we have two law offices which are operated by the state, which is the Attorney General DPP, but we also have the Chief State Solicitor. Now in Ireland we don't have a legal advisor to the government. Instead, those public offices act on the government's behalf. However, for we'll say health or for finance, those specific areas are outsourced to law firms. So as we know, the legal profession in Ireland was inherited by that of England and Wales, and it's the same in England, Wales and Northern Ireland. And we have solicitors and barristers. Now, in 2015, we had the Legal Services Regulation Act, and that act envisages that the strict role between solicitors and barristers in Ireland will begin to fade towards the future. And already in the UK, we've seen this. We have a so-called solicitor advocate, which is a solicitor who is like a quasi-barrister, as in a litigator, but who also advocates for their client in court, which would be a very neat way to solve the whole divide. The Act envisages that solicitors and barristers will be able to go into partnerships together and form a single legal firm. Interestingly enough, solicitors are the only ones who are allowed to take direct instructions from the public. There's only rare exceptions for barristers where they can take direct instructions from the public. And I actually didn't know that. What is basically the difference between a solicitor and a barrister? Well, Byrne and McCutcheon say that, strictly speaking, the solicitor tends to specialise in legal work that involves the preparation of cases for court rather than advocacy in court. And that is true. However, solicitors often do transaction work which involves non-litigious action. This is in the litigious sense. And the barrister is, generally speaking, regarded as specialising in the preparation of cases for court as well as advocacy in court itself. The solicitor is therefore on the front line of dealing with the public, and for most individuals their only contact with a lawyer will be to the solicitor, for example, to deal with legal problems, sale of a house, drafting will, commercial contracts for small or medium business. This is referred to as non-contentious business, i.e. doesn't go to court, but a solicitor might also appear in court in relation to some contentious business, for example, road traffic accidents. Let's look at the Legal Services Regulation Act 2015, because it's an area of law that's going to change a lot how the Irish legal landscape operates in years to come. The background to this is that the Competition Authority in Ireland pointed out some sheltered professions in that they are protected because of the service they provide, and also their cost structure is protected because it's an insulated market. There really is not much competition. Now there is competition as amongst law firms, but generally there is some standard pricing. So the Act was sought to reform some of that. So the main points in the Act are as follows. So the Act sought to set up the Legal Services Regulatory Authority, the LSRA, to regulate both solicitors and barristers, and acting as an independent complaint structure to deal with complaints for professional misconduct. A review by the LSRA of the monopoly on legal professional training for solicitors. So the Law Society of Ireland has a monopoly in training solicitors in Ireland, unlike the UK, which has multiple providers. And also the King's Inns in Ireland also has a monopoly on training barristers. Also, because of the liability that solicitors are exposed to, the Act also sought to see a development of new business structures, namely the limited liability partnership for solicitors, the legal partnership firms comprising barristers and or solicitors and barristers, and consideration of multidisciplinary practices. This would include solicitors, barristers, accountants and other advisors, business advisors. And finally, the establishment of a legal cost adjudicator, which would replace the taxing master in the High Court. So the next thing we have to look at is the number of practicing lawyers and access to the profession in Ireland, okay? So we're told by Burnham McCutcheon that since 1960, there has been a 22-fold rise in the number of solicitors in Ireland. So in 2019, the figure was nearly 23,000 people, as opposed to 1960 when you had roughly 1,300 people. Interestingly, in Ireland, 81% of those being admitted to the profession are foreign lawyers. This number was inflated by the UK qualified solicitors coming here in light of Brexit. As regards barristers, the numbers have not increased to the same level, and this is simply because of demand. Indeed, in 2019, we are told there was only 82 new entrants to the barrister profession. The other interesting fact is that the top 20 law firms in Ireland, that is the 1% of the total number of firms in Ireland, employ over 20% of practicing solicitors. And that is very, very interesting. Unfortunately, the Code of Conduct of the Bar of Ireland prohibits barristers from forming arrangements such as chambers, which are common in the UK and Northern Ireland. So basically, barristers are self-employed and they rely on referrals. Comparison of lawyers in Great Britain and Ireland, which was done by the Competition Authority in 2006. So when we compare Ireland to every other common law jurisdiction, we have by far the most barristers per capita, which is extremely interesting. So we are 45 barristers per 1,000. Our nearest rival is Northern Ireland, which is 34, with England and Wales on 23. New entrants to the law library, which is the King's Inns, are leaving practice early because of a lack of earning potential, and solicitors are leaving private practice and moving towards in-house. These are the two fundamental trends which the LSRA pointed out. Further, a notable change in the legal profession in recent decades is its gender composition, which also reflects comparable changes in many other jurisdictions in Ireland. By 2019, the gender balance of the solicitor profession was 51% female. However, only 34% of Ireland's largest firms were female. The same has not been said for the barrister profession, where in 2019 only 38% were women. It's also very interesting. Which is actually the same number of female judges, which by January 2020 were sitting on the bench. So let's now look to the future of the profession. Interestingly enough, Burnham McCutcheon mentioned my man, Professor Richard Susskind, as being an influential writer and advisor on this topic to many governments in the 1990s. His analysis of the changing landscape of professional services generally and the emerging impact of ICT in the digital age has proved highly influential in the legal profession. That point I mentioned earlier, that only 1% of the Ireland's total number of law firms employs 20% of the practicing solicitors here. So this means that Ireland reflects the increasing trend internationally towards concentration in a very small number of large firms. These firms are, like their counterparts in other professional service providers, increasingly organised along cross-border lines, which means, they've got European alliances. Very interesting trend that senior members of the King's Inns or the barrister profession are being employed by solicitor firms on a full-time basis rather than on a fee-per-case basis, and this has also blurred the lines between the professions. Point about in-house. So the increased prevalence of in-house counsel led the Law Society to run a course specifically to cater for these aspiring lawyers. In-house counsel provides substantial legal services to a corporation, and in the event that it needs further advice from an external firm of solicitors or from the bar, it is like that in-house counsel would be especially familiar with the range of legal services available and the appropriate fee expected. Susskind has commented that another function of in-house is to reduce the overall cost of legal services for the corporation. Most jurisdictions, including Ireland, have become increasingly regulated, and this has increased regulatory compliance costs that require legal advice. So basically, the more regulated we become, the more in-house counsel becomes a need. And also, in-house solicitors are moving law firms away from the hourly and daily charging rates, and we are moving them towards an annual fixed fee arrangement for the services in order to reduce overall cost to the in-house function, and we call this less for more. Bernard McCutcheon references Richard Susskind and his son's book, How Technology Will Transform the Work of Human Experts, pointing out the 4 big developments in IT that they see up until 2025 will be extremely relevant to the legal profession, which are the exponential growth in IT, which is Moore's law, which is the computing power or processing power of a human brain, the increasing capability of machines through big data, AI, robotics, and effective computing, which is computing that can detect emotions and express emotions, increasingly pervasive devices, like ones that can read us, and increasing connected humans. In terms of legal innovations, the 3 they focus on are online dispute resolution, and I think I mentioned that during the summer about PayPal. I was involved in a dispute myself on PayPal, and I thought it was fantastic. Virtual courts, we have judges, and we have witnesses dialing in, and this was the COVID was the catalyst for that, and automated preparation of legal documents through a lot of online forums. For example, Rocket Lawyer and LegalZoom, they are preparing these documents online. You can pay for a solicitor to review them. Some people don't agree with Susskind. Professor Jennifer Miller points out that the Susskinds are not the only writers who have predicted change. She knows that they've written about the disruptive effects, but she suggests they've put too much emphasis on market-related approach to the profession and did not pay enough attention to the rights-based analysis of issues such as data privacy. So basically they're saying that machines are going to take over, but they're forgetting the human need for privacy, which is a fair point. They need to be balanced. Right, let's look specifically on solicitors training. So usually before you become a solicitor, you fulfill your training, whereby you complete your articles of indenture. And just so all of you are clear, some people ask me, what is an indenture? An indentured servant, for example, this word is quite archaic, but it actually comes from, when you have 2 sides to a page and down the middle there's an indent, which means you tear it off. So you get one copy and I get the other. And for the servant, it meant that they were there for life. Whereas indenture means I'm the servant, I'm the trainee, you're the master, and they used to be called trainee and master back in the day. And the indenture was simply the contract which bound you together. I got one copy and you got the other. So let's take our journey to become a solicitor back to the very, very start, and let's start with the FE1. I always wanted to read up on the history of the FE1, so now we have the chance. So the FE1 is a crucial examination in terms of the transition from university to the Law Society examination. It comprises 8 core subjects, and we all know what those 8 core subjects are. Now listen to this, all y'all. Prior to 95, pursuant to the Regulation 15 of Solicitors Acts 1954 to 91, the Law Society granted an exemption from the FE1 to law graduates from the universities of the Republic of Ireland to those who had completed the core subjects in their law degree. Okay? So listen to that, right? So you didn't have to sit the FE1, so you didn't have to sit the FE1 if you had done those subjects in university. But what happened next is why you all have to do the FE1s, okay? The exemption was removed after Bloomer v Law Society of Ireland. In that case, the plaintiffs, who were law graduates of Northern Ireland universities, sought parity with their counterparts from the Republic of Ireland. The High Court, Justice Lafoy, held that the exemption for law graduates from the university in Ireland was invalid because it was in conflict with the prohibition of discrimination on grounds of nationality in what is now the TFEU. In light of the High Court decision, the Law Society stated that it would from the time require all persons to sit the FE1 examination rather than to extend the previous exemption, pursuant to Regulation 30 of the 91 Regs, which empowers the Law Society to modify any requirement of the regulation in exceptional circumstances. It decided that the plaintiffs in Bloomer should be granted an exemption from the FE1 exam. Later in 1996, in Abrahamson v Law Society of Ireland, over 800 undergraduate law students in the Republic's universities sought to restore the position prior to Bloomer, at least for those already in the system. The High Court, Justice McCracken, held that since Regulation 15 had been declared invalid in Bloomer, the 800 applicants were no longer entitled to rely on the exemption from the FE1. However, he also held that the position of the 800 applicants constituted exceptional circumstances because they were, just in before the ruling under Regulation 30, and they were given the exemption. The Law Society subsequently declined that all law students attending courses for the previously exempted law degrees at the time of the decision in Abrahamson were exempt from the FE1. Thus, students who began their law studies in universities in the Republic from 1996 to 1997 had no exemption from the FE1. In the next video, we are going to look at barristers, and we're going to do quite a deep dive on barristers because I feel like I'm ignorant about the barrister profession and I want to learn more. Therefore, we will do a video on barristers the next day. I'm really looking forward to it and I hope to see you there.